Good morning, and thank you for joining us for today's Workers' Compensation 101 webinar. I'm Sarah McDonald from the Board Stakeholder Engagement Unit, and joining me today is Joe Cavalcante, the Board's advocate for injured workers. Today, Joe will cover the basics of workers' compensation system, including employees' rights if they become injured or ill on the job, employees' benefits under workers' compensation, how to file a claim, how to get help with your claim if needed, and best practices for injured workers. We ask you to please keep your phone lines muted as we'll be using the chat feature to receive your questions today. You may enter your questions throughout the presentation in the chat box located on the right side of your screen. Joe will answer as many of your questions as he can, but if there are any that he doesn't get to, or if you think of something after the session ends, we'll be providing you with additional resources at the end of the presentation. Your name and email were given to us when you registered. However, if you have a specific topic you'd like to discuss more in depth with the board, please share that topic along with contact information in the chat box so the appropriate board staff can follow up with you. The chat settings are set so that only panelists can see questions or comments that come in, so you do not have to worry about others seeing your contact information. And with that, I will hand it over to Joe and we will get started.
Thank you very much, Sarah, and hello, everyone. It's a pleasure to be with you on this, at least here, it's a snowy morning in the general Schenectady, Albany Capital District region. We are going to go over the basics of the comp system today, and questions are always welcome, so feel free to pose. Thank you for giving us some questions in advance. We have looked through them, and we should be able to answer them while we go along, but if we don't, definitely feel free to pose them again in the chat. Sarah and I watch the chat. Sometimes we answer your questions in the middle of the presentation. And then finally, if you would like a presentation on comp for your organization, whatever it might be, let us know, because we have definitely picked up individual presentations from these sessions. So why don't we begin before there's ever an incident, before anything has ever happened, and talk about how we might create a safer workplace. One thing you can do is create what's called a Labor Management Safety Committee. This is something that comes out of organized labor, and it is simply, well, it's people talking. It's a committee of workers and managers who get together and they review what's happening in the workplace, either where incidents are occurring that are hurting people or that could potentially occur. But either way, they take some steps to mitigate or prevent the incidents from happening. We have some suggestions on screen for what you might want to do to form such a committee. But the important thing is, get out of the conference room, go into your workplace, look at how you do tasks, which tasks you do, what equipment you use, what your training is, who's doing the training, and just reorient everything for safety. You know, this is the kind of thing that it's simple and it's free, and it could save a life, including yours. So why don't we now move into workers' compensation, as in what is it and what are the workers' rights? And by extension, the rights of the employer as well. It's a no-fault insurance system. It's like auto insurance in that regard. So whose fault the incident is not a factor. It's an insurance product. It's an insurance policy, actually, workers' comp. And where there's not an insurance policy, there's self-insurance. We'll talk about the difference in 10 minutes. But there's insurance there to protect the workers should they get injured or ill, or in the worst instance, suffer a fatality. There are benefits available for lost wages and for medical care. Healthcare, I should say, because it extends beyond medical into psychological or chiropractic. And it also protects the employer because the employer is absolved of liability. workers' comp is known as the grand bargain. It's the grand bargain between workers and their employers. I mentioned that this is insurance. There's no cost to the employee, to the worker, for the insurance. They can't be charged for this. So you won't see a deduction on your pay stub the same way you might see a deduction for paid family leave. Also, there are a few more things we need to tell you about. If you're injured or if you're made sick at work, you're entitled to workers' comp no matter how the injury occurs or the illness occurs. It's your legal right, workers. You cannot sign it away. You cannot negotiate it away. And as a matter of fact, you can think of the benefits that we're speaking of today as the minimum, because workers certainly can and frequently do negotiate richer benefits. Also, immigration status is not a factor. This is one of those few places where I can make a categorical statement like that. Immigration status is not a factor. And as a matter of fact, on that topic, Governor Hochul would like us to point out to everyone that we do have some state resources that New Yorkers can call upon if they have questions about immigration. And we are showing you that webpage right now. There's a Know Your Rights endeavor from New York State. There's the URL. I think Sarah's probably already getting ready to pop it in your chat if you want to check it out. You can visit that page yourself. But New York State recognizes that the U.S. and New York State in particular, we're a place of immigrants. So the state is making some support services available on the subject of immigration. And then finally, language assistance is available from the board. So if you don't or would prefer to speak another language other than English, we have you covered. Sarah's showing you right now the website or the web page on our agency site. Look at all the languages we're showing you right there where our materials are readily available. There are a dozen languages there. And then if you are a worker and you would like an interpretation in another language, we will do it for you at no charge. I think the latest stat I saw was that the board did something like 88 different languages, has done 88 different languages this year for interpretation for workers. So we're committed to this. All right, let's get a little deeper into the comp system now. And let's explain what the Workers' Comp Board is. This is the New York State government agency that employs Sarah and myself, and we regulate the workers' comp system. We are the administrator of the workers' comp system. There are about 1,000 of us across offices and hearing points all around New York, a couple dozen places where the board is operating. And we do our function by receiving reports of injuries and reports of treatment and reports of payment. We get all the documents and we have to, okay? So that is key in our ability to regulate in this system and also to do some of the other functions we engage in, such as hearings, which we'll talk about later, and moving claims forward. Now, within the board, there is this advocate for injured workers, and technically that's me. That's my title. My civil service title is actually ombudsman. That's that first bullet there. An ombudsman is an office that you see in the U.S. that tends to be placed in certain types of organizations that might want someone to be not directly involved in the direct business of the entity, but who can field inquiries from people outside and take a look at them and see if the organization or the system is operating in its intended manner. We tend to work for places like hospitals or financial services corporations. So my staff and I, because there are 7 of us right now, we receive reports from workers about issues in the system. We investigate them and attempt to resolve them. And along with that, we help workers with the most difficult and complex claims. So if it's hard, we're probably going to get called in to help the worker. And the amount of help we can give, or the type of help we can give, is actually quite different than what an attorney might be able to do. Sometimes we have to explain that. We can't give you legal advice. We can't represent you at a hearing. But we can certainly explain to you what is happening and what the benefit situation is and so forth. We are also involved in fatality claims. We'll talk about that benefit in a little while. And I am the board's primary liaison to the 9/11 community. We're going to show you now 2 federal programs that are still in existence today. The advocates go to Washington regularly this year to fight for their continued existence. On the left, the World Trade Center Health Program. This is a federally funded medical monitoring and medical treatment system for people whose health was either jeopardized or impaired by the events of 9/11 and the aftermath. If that's you, I'm urging you to enroll in the World Trade Center Health Program. This is a national system. I think there's only 1 zip code in the United States of America that does not have someone enrolled in the World Trade Center Health Programs. On the other side, there's the September 11 Victim Compensation Fund. The government, the federal government, put aside money many years ago to help pay financial compensation for physical illnesses or deaths related to 9/11. Now, this is for both responders and survivors, including residents. Okay, our system is for the workers, but survivors and workers can do the Victim Comp Fund. They're taking claims, they're still taking claims, so I recommend, if that's you or someone you know, you check into the September 11 Victim Compensation Fund. Okay, and to do all these tasks, I report directly to the chair of the agency. Let's move into a new topic now. Who pays your workers' comp claim? This is what I call foundational. You have to understand who's paying to understand what the benefits are and how to access them. Okay, remember I said it was insurance? Well, your employer has a choice. It can either buy an insurance policy or self-insure. I'll tell you about both. Buying the insurance policy, that's the easiest. Last year, 300 different insurance carriers wrote workers' comp insurance in the great state of New York. And that's the real number. It was 300 exactly. That's 10 more than the previous year. So the business can, or the nonprofit can buy a policy, and there you go. The carrier, the insurance carrier, is going to pay the benefits. They're also going to make all the decisions in the claim too. The other way is self-insurance. Now, self-insurance is much more specific an item. Who self-insures? Self-insurance means that an entity, such as a public or a private entity, okay, so you can be a public, like a government, or a private, and you can self-insure, which means you have the funds available to pay the claims yourself. That's going to require a lot of money. So public entities like towns and cities and school districts, they can do that. Private employers, it turns out there are about 90 private employers in New York who have wherewithal, the financial resources to post collateral with us, because they have to do that, and then have the funds available to pay the claims. They tend to be multi-billion-dollar international corporations. But self-insureds usually, not always, but usually hire a claim administrator. That's an entity, sometimes known as a third-party administrator, who will actually handle the claim. It'll get lawyers to go to the hearings, it'll send out the payment, it'll review the authorization request. So the point here is whether you are a worker and you have an employer who bought a policy or an employer self-insures, your employer is not making the claim decisions, almost assuredly. You're certainly not going to get any information from your manager or your human resources or personnel. They're not involved in the claim. Closest it gets is if an employer is extremely large, like the City of New York. City of New York is an extremely large self-insured, but what they did is they created a whole division of people known as the law department, and they handle the claims. So if you work for Parks, your boss is not doing your claim, the law department is. Finally, that last bullet is very important. If there's no insurance in place, and there should have been, the board will advance the payments, and then we will bill the owner of the business personally. So that person is going to be in a lot of financial difficulty because they're going to have to pay us back. And you know how much medical care costs, and you'll see how much lost wages can be. So seriously, if you don't know whether you should be carrying insurance or not, do you have employees? Then you should. At a minimum, take the Advocate for Business webinar. Okay, let's talk a little bit more now about who needs coverage. Businesses with employees should have coverage. And when I say a business, I mean a for-profit. Most nonprofits are also required to have coverage if they have employees. Okay, so the common feature is employees. Why don't we talk now for a moment about who is an employee? Because I'm going to now tell you what we at the board consider an employee. And that's the thing you need to know for comp, because all the various systems, the tax system, labor, workers' comp, we all have our own definitions of employee. Here's ours. Anyone who provides services to a for-profit can potentially be determined to be an employee. Anyone who's compensated, not a volunteer, but you're compensated and you provide services to a nonprofit, you might also be determined to be an employee. On the nonprofit side, there's some obvious limited exceptions, such as clergy or teachers. They don't have to be covered for comp. But otherwise, you know, if you work for a nonprofit, there are people on this webinar right now who are working for nonprofit organizations. You're compensated, you're covered for comp. It's all about who's an employee and what's the definition. And in the comp system, it boils down to, is the employer exercising what we call direction and control over the activities of that worker? So if you're a worker and you're involved in the basic business and you're performing tasks, and you meet the criteria in the checklist. There's a checklist on our website, by the way, of 10 factors that we look at. If you're contributing in that manner to the business, we could determine you to be an employee because you're receiving direction and control from the employer. You might not be an employee for tax purposes. You might have a 1099, but there are plenty of people who get 1099s who are considered employees in our view. For example, internet businesses. There are plenty of people who work for internet businesses who we consider employees. Let's talk now about what to do if there's an incident, and then you're going to get a quiz. So, yeah, I'm not kidding. We do have a quiz for you. So, workers' comp, if there's an injury, what does a worker do? Okay, now we're into the system. We gave you all the background. The insurance is in place. If the insurance is not in place, file the claim. Repeat, if insurance is not in place, file the claim. Okay, let us worry about who's going to pay, because remember, the board is the backstop. But now we have an incident. What do? Number one, workers, go get the necessary medical treatment right now. Don't dilly-dally. Your mother was right. Your health is the most important thing. Please go get your treatment. If you are an employer and you want to help the worker get to an urgent care, thank you. You're what we call a good Samaritan. Please don't try to direct the worker to a particular doctor or a particular urgent care that you have some sort of an arrangement with. Don't do that. You're not allowed. And if you want to come into the exam room with a worker, I would ask you why. Seriously, I would ask you why. Because there's a very good public health law that says if the worker doesn't want you in there, you're not going to be in there. And the only reason I'm mentioning this is because the Attorney General just engaged in a huge agreement to pay a huge fine, it was $1.5 million, from an employer who was doing the things that I just advised you not to do. You can look it up. It was in the press. So get your necessary medical treatment right now. Number two, tell your employer in writing about the incident. You have to do this because it is going to start the chain of events that gives you a claim, a complete claim. So tell your employer in writing, and by writing I mean a document or an email. Yes, you are legally permitted to text. I just don't recommend it because you might not realize your phone is set to delete your texts after 30 days. That's right. You can pull your phone right now and look at it. The only way it's keeping them is if you change that setting. So, you know, it's very difficult to look back and find a text from 11 months ago if, say, a judge wants you to, isn't it? It's a lot easier to find an email. So tell the employer in writing about the incident and then file a C3. File your own claim form. This is going to come to the Workers' Comp Board, and it's going to go into your case. And what it means is now we definitely know about the incident. Sarah's showing it to you right now. You can see that there's some tabs. It has this really basic information like what's your info, what's the employer info, what's your job info, and then what happened. If you have an attorney, you can definitely complete this with your attorney. Don't worry about it. That's fine. But we recommend you send in a C3. If you can file it electronically, please do it that way. If your answers don't fit in here for some reason, you can always use paper. Workers can always use paper because we know you're not professionals. System professionals like doctors and attorneys, you guys might have to do things electronically, but you all know that. Okay, so file that because I mentioned the chain of events. Here's the chain of events. You told your employer now must tell the insurance payer or a penalty is possible. But they tend to tell the insurer. And then the insurer must tell the board or a penalty is possible. And they tend to. So that little chain of events, you tell the employer tells insurer tells us, that's called notice. That's half of a claim. The other half of the claim is the medical. Well, remember on step one when you went to the urgent care or the emergency department or, I don't know, some other healthcare provider? You told them it was work-related. Remember, you have to tell them it's work-related if it was work-related, so then they bill the insurer sends us the medicals, now you have a complete claim. You have 2 years after the incident to file a C3. That's you filing with the board. So just think of it this way. You have 2 years after an incident to file a claim before you get timed out, or time barred, we say. But you should be telling your employer immediately. They'll start the chain of events immediately, and then you don't have to worry about the 2 years. And now I'm going to turn it over to Sarah for your first quiz.
Hello, everyone. I'm going to go ahead and open our poll. Our first poll here is whether or not Kadir should file a claim. All right, I just launched that for you. You should be able to see that on screen. So Kadir is not an American citizen and is in the US on a work visa. Kadir works 40 hours a week on site at a software company, and the company assigns him a desk, equipment, and tasks. He's paid on a 1099, and the firm calls him an independent contractor. One day, Kadir is inattentive and drops a computer server, fracturing his left leg. The employer calls an ambulance that takes Kadir to a hospital. So in this scenario, we are looking for a yes or no response in the poll. Should Kadir file a claim? And for those of you that may have been on this presentation before, Joe gives us a lot of hints in his presentation, guiding us through here. I think he calls it foreshadowing. So, and we are looking for 50% participation in this poll, and I can see a lot of people are responding right away, which is awesome. And at this time, I also like to let you know, if you do have questions, you can put them in the chat at any time. Joe will answer them if he can during the presentation, but if not, at the end, he'll review them all and we'll go over all the questions. Joe, we are at well over 50% now and very heavily answering one way.
All right.
Tell you what that is?
Yes, please.
All right, we are almost 97% yes.
Well, that's fantastic. I would agree with that. I bet Tony does too. Yes, Kadir should file a claim, we do believe. And if someone wrote no, I'd love to know what your thinking was. So you could type that in the chat. But yes, Kadir should file this claim. And you didn't fall for any of the red herrings we threw in there. The key is that he goes to the same place all day, every day. They tell him what to do. And even though he's paid on a 1099, that's a tax arrangement. But he had an incident and he got hurt and the employer called an ambulance. So technically, if it ever became a question, that would mean the employer probably had notice. So if Kadir never told his employer about the incident and they objected, it's highly likely a judge would say, well, you had notice, you obviously did, you called the ambulance. Thank you for doing that. Okay, so let's move into now what the benefits are. The benefits are medical care, lost wages, and then the fatality benefit. So let's begin with the medical benefits. They are provided at no cost to the worker. No cost, no co-pays, no cost. And the medical care is the workers for life. This is important. Sometimes people don't remember this and they start asking us questions about how do I reopen a claim? My claim is from 1999. What do I do? It's a lifetime benefit. You don't reopen a claim because claims don't close. Just go to the doctor, give them the information, the case number and so forth. I'll show you that. And you can have this care for all your established sites and conditions. And we're talking about testing, and we're talking about surgeries and physical therapy and office visits, et cetera, et cetera. Someone just posed a question, and I'm going to pick it up because it's right on target. Here's the question that just came in. My surgeon's office, so we have the patient here or an injured worker. My surgeon's office informed me some of the pre-op testing would be my responsibility. For example, echocardiogram, cardiologist to clear for surgery. But this is covered by workers' comp, correct? Yes, it is. They are giving out the wrong info if so. Well, okay. The worker needs a surgery and there's some pre-op testing that's going to be necessary, like an echocardiogram and a cardiologist to clear this person for surgery. This is it's a pretty good question. This is a pretty good question. If you need the surgery, then you need, I would think you needed the care required to clear the way for surgery. Prior authorization requests are going to be required for this. So your surgeon is going to have to submit an authorization request for the surgery. These services are going to have to be listed in there. So let's revisit this after the authorization process. If the doctors fail to file prior authorization, then who is on the hook, the worker is asking. There is no doctor in New York who's going to do a surgery for you without knowing how it's getting paid. Don't worry about that one. Don't worry about that one. Okay, so back into the regularly scheduled performance here. Transportation costs for travel to and from your care is also reimbursable. So to access that money, you would file the form C-257. Workers, if you've been getting care, and I mean care, you know, you went to office visits, you went to PT, you went to the hospital or the urgent care, you can be reimbursed for the travel back and forth. We're showing you the form right now. Thank you, Sarah. The top of the form is very simple. What's your name, what's your case number? And then those big blocks, nature of expense. I traveled to Dr. Schweitzer's office on this date. Amount is the money, the cost, but you would also put the mileage if you drove. And then you would look up how many cents per mile. Like right now, this year, it's 70 cents a mile. So you can just use mapping software like Google or MapQuest, pick your favorite, and put down the number of miles round trip, do the math, put the dollar amount in there. If you took an Uber or public transportation, list that, send the receipt, send the receipt. If you took an Uber and you're disabled, like you're 100% disabled, and you took an Uber and the insurance company sent you back $2.90 because that's the subway cost, but your Uber is more, well, you can definitely challenge that, okay? Because the law is pretty murky on that one. Someone just asked, are all medical expenses covered after a schedule loss is determined? They should be. There's nothing in schedule loss is a particular benefit that says you have lost some use of a limb. Okay, so you got a payment for that. There's nothing in the law that says your treatment is over. You could very possibly need treatment for that limb where you got already compensated. So yes, you certainly should go for care. And if anybody should object to paying for that care, you contact my office. I don't see that objected to, by the way. We're starting to get a lot of questions about medical care. So what I'm going to do is I'm going to save the medical care questions that are coming in for later in the session, but do please keep on putting them in. I can organize them when I respond later and make it a little easier for everybody. But yes, lifetime benefit medical care. Let's talk about some best practices. Okay, workers, at the start of your claim, you're going to be temporarily disabled. As in, it just happened. We don't know that your injuries have turned permanent, so you're temporarily disabled. Okay. What you need to do is go to your doctor every 90 days or whoever's treating you. Maybe you're getting treated by a PA or a nurse practitioner. Go to the provider every 90 days. Because if you do have some form of disability, they have to document what your degree of disability is. That's one of the terms in the equation we're going to cover in a moment that yields your lost wage benefit. I'll give you a hint. It'll be between 0 and 100%. 0% means you're healthy. 100% means you can't work. So that would also entitle you to the largest amount. And also, give your providers a fighting chance to get paid here. Show up to your appointments with some key information, like the board's case number. It's probably going to start with a G if it's from this century. Also show up with the insurer's case number and the name of that insurer, please, so that they know who to bill. All right, let's move on now, and let's talk a little bit about independent medical exams. The insurer can ask the worker to attend an independent medical exam. That means they hired a doctor to give an opinion about either your health or your injury or your claim. Okay, and so you're probably going to have to go to it. Okay, if you don't go to it, if you just decide you're not going to go, if you have an attorney, definitely talk to your attorney about this. Okay, because otherwise the insurance company can stop paying you if they don't have an order to pay you. So you want to check into that. And you also want to be advised there's no doctor-patient relationship here, so anything you say can and very possibly will be recorded in a report, and it might not be recorded accurately either. I've definitely seen that happen, sometimes humorously, although it's not funny. So, workers, you may bring a witness. Don't let anyone tell you no. You may bring a witness. You may also record the exam, video and audio. You can use that cell phone in your hand all the time. Have your friend record it on the cell phone. Don't let anyone tell you no either, and you don't have to give anyone prior notice either. The reason you might want to record it, if you wish, you might want to record it because there's going to be a report filed, and you will want to check all the findings in that report, and you want to know where are they coming from and are they accurate. So if you have a video of everything, there you go. Now, if you see something in the report that you don't know where it's coming from, and you look at the video and you show your lawyer the video, and all of you say, yeah, that's not on that video there. I wonder where it's coming from. If you want to make a complaint about that, you can and you should send it to the Advocate for Injured Workers. That's my office. I will see it, and I will almost certainly refer it over to the provider committee, who will investigate it and come to some sort of a decision on the matter. Because my agency does license the independent medical examiners, and it does license the firms who employ these people. And we can and we have removed the license of examiners and firms. Also, you can claim travel reimbursement to and from an IME. And given the distances that workers are routinely asked to travel I mean, upstate workers are routinely asked to go 50 miles each way. So yeah, that's a lot of money. You would use Form C-257, and I'm answering someone's question right now. Where can you get the form? You can get it on our website. You can definitely get it on the board website under Forms. All right, next up, let's talk about the indemnity payment, the cash benefit. Technically, it's called indemnity. Cash benefit is based on all of your wages, and then there's a formula. So number one, you have to report all of your compensation. That does include overtime and bonuses and tips because it's all of your compensation. You also have to report all your compensation from all your jobs. Many of us have multiple jobs today, don't we? Well, if you can't do one job, you can't do the other job. So that's another good reason for filing a C3, because the C3 says, where else are you employed? And all those wages are the basis for the benefit. Now, the benefit is 2/3 of what you were earning on average per week. We call that the average weekly wage. 2/3 of that amount is your maximum benefit. That would be you are 100% disabled. We go over this formula in great detail in the Workers' Comp 202. So if this is of interest to you, and we have no idea how it couldn't be, sign up for our 202. We're doing one of those this month as well. Every month we do the 101 and the 202. So you can get as much Joe and Sarah as you want. Frankly, you can also take some of our other webinars and you can get more Sarah. Like, are you interested in providers? Are you a provider? There's a provider webinar tomorrow at noon. Sign up for it. It's good stuff. I've seen it. Now, the maximum amount you can get paid is on screen there, $12.22. And the minimum amount you can get is $325 a week, except if you were earning less than that. If you were earning less than that and you can't work, then you would get your full wages. If you were earning less than $3.25 a week, you had to have been part-time. Okay? There's no minimum wage in New York that yields $3.25 a week. All right, so let's do some more on your cash benefits. All injuries are temporary unless they become permanent. Only about 7,000 injuries a year become permanent. We get 165,000 claims a year, but about 7,000 a year become permanent. So it's in that range. So you can see that most injuries, thankfully, resolve without permanency. So you can have permanent partial benefits, which means you're not 100% disabled. You'll get those for up to 10 years. Or if in the worst instance, the next to worst instance, actually, if you're permanently totally disabled, you will get paid for life. And there's also the scheduled loss of use benefit, which we referenced earlier. This is a benefit should you injure a limb, arms, hands and fingers, legs, feet, and toes. And if it doesn't come back 100%, there's a payment for that. If you would like to know more about the many benefits, visit our website, go to the bottom of the page, and search publications. This is the bottom bullet. Go to publications, and you will see dozens of different publications explaining our system. Highly recommended. How's about a best practice or two for payments? Okay, real quick. Number one, if you are receiving payments and you have a bank account, or you can get a bank account, would you please, please, please consider using direct deposit? because otherwise you're getting a paper check, and I have no idea why you would ever want to go out to the mailbox and get paper checks in the year 2025. Okay? I'm not kidding. Please sign up for direct deposit. And also keep some records if you get paid in cash. This is highly significant. This is very important if you are a day laborer or you work construction in a city, because, yeah, there are a lot of people who get paid in cash, but let's say you have an injury. It's now your word against someone else's word. If you kept a record and you wrote down who paid you on what day for doing what and how much, you now have what's called a contemporaneous record, and that might be just what you need to get the benefits, or at least the correct benefits. Now, finally, the saddest and potentially most significant benefit is the fatality benefit. Yes, if a worker perishes due to employment, there is a fatality benefit. The first side that we're going to look at is the funeral and memorial expense. So in the classic view of New York State, the downstate region, New York City, Long Island, Westchester, and Rockland, up to $12,500 is reimbursable. In the rest of the state, $10,500 is a funeral and memorial expense. And then there is a weekly payment that you get every 2 weeks to the survivors. Here's how it goes. We first look for a lawfully wed spouse. Gender is not a factor, okay? Then we look for children of the deceased up to the age maximums, 18 or 23 if in higher education. Then we look for disabled or blind dependents. We do this all at once, obviously, but the benefit is spouse and children, spouse, children, disabled or blind dependents, spouse, disabled, blind dependents. And if those parties are all there, they're sharing the one benefit. Or if they're not, then just one of those parties is getting the benefit. If none of those parties exist, $50,000 is payable to the parents of the deceased. If none of these parties are around, $50,000 is payable to the estate. So that means there's an executor. And that's where it ends for us. So we might pay $50,000 to the estate, but Cousin Mel from Iowa has to deal with the estate, not us or the insurance company. Now, we do want to tell you about these two things. We want to tell you about these two nonprofits that have scholarships for the kids of workers who are, well, if the workers died or were grievously injured. There's Kids Chance. This is a national nonprofit. They have a chapter in every jurisdiction, and they will give scholarships. You can see it on screen. Scholarships for children of New York's fatally or seriously injured workers. The URL is there, kcnewyork.org. You have to go here yourself and check it out, but we recommend you go there and check it out. I just spoke to the president of the New York State chapter yesterday because I work with them to try and help people get this benefit. There's another scholarship, and I also work with those folks at the Triangle Shirtwaist Factory Fire Memorial. They also do scholarships to the same cohort, children of workers who were grievously injured or who perished, and their URL is trianglememorial.org/scholarship. See that list? Those are all institutions who received the scholarship money. Look at all those colleges. So if this is you or someone you know, just do a good deed, please, and help them get to these places, because I do also know that these folks always have money they want to give. Okay, let's move now into another quiz. This is your last quiz, but it's a good one. Take it away, Sarah.
Hi, everyone. All right, I'm going to launch our last poll of the day. And this is in regards to Liz. Liz worked full-time as a bartender at an upscale restaurant. She also worked some mornings at the family hardware store. She had a serious incident with a box cutter at the hardware store, and she missed 4 solid weeks of work from both jobs, rated 100% disabled by her treating doctor. So in this scenario, what is the proper amount? Because she was hurt at both jobs, will the benefit be based on her earnings from both jobs, or and that job and the restaurant pay and the tips are not included? So let me say this again, I apologize. Because she was hurt at the part-time job, Liz's benefit will be based on her earnings from that job and the restaurant pay, and the tips are not included. So once again, we're looking for a true or false here. And I think that there was plenty of foreshadowing earlier in Joe's presentation. He was kind of giving you some clues to this. Once again, I also saw that there are plenty of questions coming in. As Joe reviews the questions later, I'm going to drop some links in the chat that were requested. I'll just backtrack a little bit while he's reviewing the questions and get those links for you. We do need a few more people to participate to get to that 50% mark. And I
Yes,
can
this
see
is a true and I'm sorry.
Go ahead, Joe.
I was going to thank you. I was going to help them along by saying this is a true and false. So if you think that Sarah's benefit, Liz's benefit, is only based on her earnings from the part-time job, the one where she got hurt, if you think it's just coming from that job, you say true. If you think both of her jobs' earnings are going to be combined and her benefit based on that, then you would say false. I'm definitely sure I said that right.
Yeah, we've passed our 50% threshold here. We have about 2/3 of the attendees are saying that it would be false.
Those are the folks that see it the same way I do. I think Sarah does. Here's the thing. Remember, when you are injured, Liz missed 4 solid weeks of work from both of her jobs. Both of her jobs had comp policies. She couldn't work on either one. So if you really want to know the details, one of the insurance companies is going to pay her for the amount that's based on both jobs, and then they're going to get reimbursed by the other company behind the scenes. So the worker will never have to worry about that. But if you can't work one, you can't work both. That's why we say fill in a C3. That's why we say tell us your wages so that you get the proper amount. Let's look now at penalties for late payment. Well, I love how they zip in there. So workers, let's say you are at the start of your claim and everybody's on notice that you had an incident. This is why you tell everyone immediately. You have to start getting paid your lost wages within 18 days of the incident or 10 days from when you gave notice, whichever is later. So it's fairly quick. And guess what? In a complete claim in New York, 90% of the time, you will get your benefits on time. I've been trying to get the national stats on that. I don't think any other state has as high a rate as New York does. Okay, also, let's say you have a hearing. Okay, you have a decision. At the bottom of the decision in the right-hand corner on the page will be a filing date. The money has to be released within 10 days of that filing date. Now, let's say you're getting ongoing payments, like every 2 weeks. That's called an ongoing payment. Your payment's not late until it's 25 days late. That's why I urge you to sign up for direct deposit, because the chances of being that late with direct deposit, they approach 0. And also, interest can be due after an appeal. So this is a little reminder to my friends in the payer community. If it's been appealed and you owe interest, please calculate it and get it out there after the appeal's done. Workers, you do have some responsibilities in this system. You should try to come back to work as soon as you're physically capable. It can get you back to full wages, for one thing, and the employers love it because then there's no more pressure on their workers' comp premium because you're not getting the lost wage payment anymore. An enlightened employer, and I say that deliberately, an enlightened employer will help you come back and offer you transitional duty or light duty if you're still somewhat disabled, but there is work that you can do. So I just put that out there, and I hope that workers and their employers will get together on that, because employers, you're allowed to talk to your workers. You seriously are. You're allowed to express human compassion for their plight because they got hurt, and you are allowed to try to bring them back in transitional duty. The board's VOC rehab counselors can help with that. And also, the last bullet is really important here, and it's the answer to some of the questions. Sign up for eCase. We have this tool called eCase, and you can see your case folder. You can see all the documents therein. If you sign up for eCase Access, you can see what we see here at the board and what the attorneys see, the insurers see. We're all looking at the same thing. There's no secret, okay? So workers, sign up for eCase. We're showing you the screen right here. It's really simple, and it'll change your experience for the better. Let's talk about hearings now. There's the sheet, by the way. There's the sign up that Sarah's got it on screen for you. It's really simple. Okay, so now if there's a hearing, it's going to be virtual. You're not coming to the board for a hearing. We don't do those anymore. So everyone's going to do it either on a teleconference or by phone. You're going to get a hearing notice that tells you how to connect to the teleconference. It also tells you how to do it by phone if you need it. A judge calls you if that's the case. A judge calls you if you want to do it by phone. You have to tell us ahead of time. And so you're going to have this hearing. The insurance company is definitely going to be sending a lawyer, so you can hire a lawyer too if you like. Sometimes it's an excellent idea. Most of the time I could say it's an excellent idea. There might be witnesses, there might be depositions, there's going to be a workers' comp law judge. And I have to tell you something, because I got a very detailed letter yesterday to the advocate mailbox where the worker was very displeased that the judge did not allow the worker to make statements and soliloquies and monologues, and that's not how our hearings work. Okay, they're short. They might be calendared for 8 minutes. If you look at your hearing notice and you are calendared for 15 minutes, that's a long comp hearing. I think the longest I've ever seen is 1 hour, and that was a trial. Okay, so workers, we're not like what you see on television. We don't use the formal rules of evidence and procedures that courts use because we're not courts. You're not coming to court. It's administrative law. It's different. But we do try and make it polite and civil. So if you have a hearing, workers, I recommend you attend, and I recommend if you have an attorney, follow your attorney's advice to the letter. And if a judge gives you a direction, I recommend you follow the judge's direction to the letter. That's not legal advice. That's what we call common sense. Okay, last slide here is the Injured Workers Toolkit. We have an Injured Workers Toolkit. What we did is took all of the injured workers info and we collected it on this page. And I bet you it's going to appear in the chat now. And you can find all of the resources we are speaking of on this page. So recommend that you check it out. Look at all this good stuff. This is, if we kept scrolling, it's like 14 feet that we would have to scroll through. So recommend, if you want some resources and some help, you check that page out. And in addition to that page, you can also check out our social media presences. And there they are. The bottom one, get notifications. You're probably already signed up for that. But if you're not, you can sign up to get notifications from us regarding the topics you're interested in. So if you're a doctor or medical office and you're listening to me right now, you can click and say, I want everything about healthcare. Okay, we try to make it easy for you to stay involved. There's also the Office of the Advocate for Injured Workers. That's my place. There's our contact info. There's the phone, there's the email. If you send us an email, please give us your case number. Please give us your case number, your board case number, not your insurer number. Okay, because then we can look you up. Otherwise, we can look you up by name, and we can. Don't be surprised if you get an email response within 5 minutes, because we are that quick. And if you make a phone call into our office, you're probably not going to have to wait much, or if at all, because we're pretty available to you, and we will help you. And now I'm going to turn it back over to Sarah.
Hi, everyone. Well, Joe is reviewing the questions in the chat. As promised, I'm just going to backtrack a little bit here to be able to throw a couple of the requested links into the chat. Also wanted to remind everyone, we do record these presentations, and there will be this presentation and other of the Workers' Comp 101 and 102 are available on the board's website as well as the board's YouTube page. If you go to the main page of the board's website and scroll down to the bottom of the page, you'll see recorded webinar section, and you can find this webinar as well as many of the other webinars that we do. Our first request for a link, I believe, was the language assistance. So I'm just backing up all the way here.
Terrific.
Joe, if you're ready, go ahead, and I'll just kind of drop these in as you're doing your Q&A.
Thank you. Okay, let's do that. The first one, I'm going to take advantage of your offer to help. I was going to find the link to the fatality fact sheet that someone asked for, but I'm going to let you do that one, and then I will go into some other items. All right, number one, what is the name of the book for workers' comp laws and statutes? Okay, you're asking about the workers' compensation law. That's the name of it, the workers' compensation law. There is also a companion book that explains the workers' comp law known as McKinney's. Okay, McKinney's is an explanation of comp law to some extent. If you want to see these in book form, yeah, maybe a public library has them. The New York State Library has them in Albany. You can also get them online. I don't know exactly what you're going to do with them. If you're going to like open them and attempt to read them, I wish you the best of luck. But yes, you can get the actual law if you really want it. The people at the Kind Souls Foundation welcome the opportunity to co-host meetings. Okay, well, if you would like something with me, to my friends at the Kind Souls Foundation, contact. Send an email to the Advocate mailbox, and we'll arrange for something. Yes, we can provide our materials in Greek. We don't have them readily available in Greek because it's not one of the 12 most spoken languages in New York State. But yes, I promise we can certainly translate into Greek as necessary. And if we got a letter or an email in Greek, we would respond in that language. Can you send me more information about the Ombudsman handling fatality claims? Well, we're going to get you the fact sheet on fatality claims. We'll paste that in there if we haven't already. I'm not looking at what Sarah's giving you. I'm looking at your questions. If you have a fatality or you know about it, if you need to call my office like as soon as we're done, okay? Don't ever delay on a fatality, please. Somebody said, how about potentially includes internet businesses? Yes, internet businesses frequently are carrying comp policies, even if they don't tell you. So there's a term that's used often now called a side hustle. This is coming out of the internet businesses who don't want to use the word job, who don't want you to think that you might have a job and might be eligible for comp or some other benefits. Thank you, Sarah. That is what I was talking about. But a side hustle could easily make you an employee for comp purposes. Okay, here's a full question. I have an occupational injury left knee from 2017. I have another case open on the right knee from 2024. Due to severe arthritis, I'm getting both knees replaced on Thursday. Oh my gosh. Well, I wish you the best of luck. I have not been paid any lost wages or expenses. Was I supposed to file a C3 or something else? Lawyer has been filing some stuff on. Okay, so you have a lawyer. That means you have claims. And you haven't been paid any lost wages. Okay, why is that? Have you missed time from work due to these injuries? If you have not, then no, you wouldn't be doing any lost wages. Have you missed time, though? If the answer is yes, why didn't you get paid? Would you like us to look at the claims? If you would, call that phone number on screen right now or send an email to that email address and give us your 2 case numbers, please. If you only have one, that's okay, because one claim will almost certainly show us the case number for the other one. And we'll look at it for you and see why. But if you haven't been paid any lost wages, if you haven't missed time, you're not going to get lost wages because you didn't miss any wages. Now, you are in a position where you're getting your knees replaced. So now we can talk for a moment about the schedule loss of use benefit. I want you to recover 100%, of course. If you don't recover 100%, you could have a schedule loss of use payment because you're not 100% healed. That's what that payment is for. You don't have to miss time to get that payment. That payment is because you permanently are impaired in a limb now. So to anyone who's listening who likes to point out schedule loss of use claims, the worker doesn't have to miss any time. No, they don't have to miss any time because they have lost part of the use of a limb permanently. That's what the benefit is paying. All right. I'm looking now. Are all medical expenses covered after schedule loss of use is determined? Look, if you have an SLU, schedule loss of use, and you need more medical care, go get the medical care. Okay, there's nothing about an SLU that says your medical care is over. You could have an exacerbation. Your SLU could have been paid saying you lost 10% of the use, but as time went on, guess what? You got worse. Now you've lost 20% of the use. You can get paid for that. The law understands that we're not static. We can get better, but we can also decompensate or become more injured over time. Here's a question. This about medical care. Workers' comp keeps denying my doctor's pre-certification for injections. My doctor has exhausted all appeals. I'd have to now appeal to the judge. What laws can I use in my filings? Okay, so this is the person who was asking about the law books, looking to quote law. Okay, here's what's going on. This person has a doctor who prescribed injections of some nature to treat something. Based on this, what I'm reading is the insurance company rejected it at level 1. The insurance company rejected it at level 2. And then the doctor elevated it or escalated it to level 3, and the board medical director's office rejected it or didn't approve it. Is that the case? Is that what actually happened? You went through all 3 levels? Because if you did not go through all 3 levels, well, you still have the medical director at the board available. You should call the medical director's office and find out the procedure if that's the case. But if it was objected on level 3, if you want to put it in front of a judge, yes, you can file what's called an RFA 1W. That's what a worker would file if a worker did not have an attorney and a worker wanted a judge to consider it. You don't really need to quote law, okay? It's if you have an attorney, you need to let your lawyer do this. If you don't have an attorney, I can't really tell you how to argue it, but I can just remind you that I don't know if you're arguing the law or if you're arguing the facts of your care. Okay, so definitely always pay attention to the facts of your care. You can also call us, by the way, or write to my office, and we can restate this for you and maybe look specifically at your claim. That might be very helpful. Can I be reimbursed if I saw a doctor for my injury and paid with my personal insurance? All right. Sometimes people use their personal insurance rather than filing a comp claim because, in the best of circumstances, they didn't realize it was comp injury. Now we're back to the 2 years. Has it been 2 years since the incident? If the answer is, oh, it was 10 years ago, then just move on. If it was not, then you can file a comp claim and you can see about establishing it in the comp system. And then if it does get established in the comp system, the comp insurer will pay back your personal health insurer. That's called the Health Insurance Matching Program, or HIMP. This is a real thing. It happens every day. I'm having trouble finding a doctor and I need a neurologist. My neurologist won't see me every 90 days. Okay, so we have 2 things here. Your neurologist won't see you every 90 days. Are you receiving lost wage payments? Like, are you temporary? And are you injured enough that you're getting payments? If your neurologist won't see you every 90 days, find someone who will. Go to one of your other doctors, because you're not going to be getting those benefits if there's nobody saying that you're disabled. See, that's what they're doing. They're saying you're disabled because you're disabled. If you need help finding a neurologist, go to the board's website and select the button that says Find a Provider. We have this tool that you can look up and see who all the neurologists are in New York who do comp, or you can see who all the orthopedists are, all the PTs. Yes, we have a tool that you can look them up. And if you need help doing that, you can contact the provider unit and they will help you find a doctor or other provider. Suppose you are physically unable to work one job because it's manual labor, but you are able to work a second job, teaching. No, you're not. If you're partially disabled, that implies you can work both. If you're totally disabled, you're totally disabled. So if the manual labor, if a doctor says you're totally disabled, we appreciate the fact that you want to try and work, but you can do that, but you can't get a benefit. Repeat. If you do work while a doctor says you're totally disabled, that means you're not totally disabled and you can't get paid a lost wage benefit. If you do, that's called fraud. You've now committed a crime. My primary care provider does not want to complete my CMS 1500 because my injuries are neurological. She thinks my neurologist should be doing this, but I can only get, okay. You and your doctor are probably talking about two different things. If you're seeing a primary care provider and you have a comp injury, what's your provider treating? Okay? What's the provider treating? Sounds to me like your provider, your doctor here, your primary care provider, okay, your PCP. Sounds like your PCP is saying, I can't treat you. You have a neurological injury. Go to a neurologist. Okay, go to the neurologist. Part two of the question is, I can only get an appointment every 6 to 9 months. Get a different neurologist. It's that simple. Get a different neurologist. How am I supposed to see a doctor every 90 days when docs don't want to deal with comp? There are 24,000 doctors in New York who are signed up to do comp. Use one of those 24,000, okay? I know that there are doctors who don't want to do comp, but I do know there are plenty who do. So find one who does. Use that lookup tool. All right, I am going through the questions. I see Sarah's put in a whole bunch of links. Thank you for doing that, Sarah. I just heard from the lawyer. He said they will work on the benefits after surgery first, as it is clearest, and then address the lost intermittent time prior to surgery. Thanks. I will follow up with your office next week. Oh, thank you for telling us that. Thank you for indicating we have had some sort of success already. Yes, let me address this idea that our worker brought up known as lost intermittent time. Lost time on an intermittent basis. Okay. Did you have a degree of disability when you were losing time before the surgery? If you did not, then let me know if your attorney gets you a benefit for that. It's going to be hard. But if the attorney is willing to try and has an idea about what needs to be done, more power to you. If you had a degree of disability and you never got paid, yes, you absolutely should be pursuing that lost intermittent time. My NP is my primary care. Yeah, okay, all right, I'm sorry, I answered that one. Please repeat the statement about partial or complete disability and working or not working more than one job. Okay. Also, if you have more questions, type them in because I'm at the end of the questions. But here's what I just said, and it's very important. Partial and total disability. If you have a provider saying you are totally disabled, 100% disabled, that qualifies you for the maximum benefit you can get in terms of dollars. Okay. If you are getting paid total disability, you can't work. If you start working and you're getting paid the benefit, do you see how you're double dipping? You're getting paid twice for the same thing. You're getting your wages for working and you're getting an insurance benefit for not being able to work. That's a fraud. Now you're in trouble. If you have a partial disability and you want to work, you certainly can because you're only partially disabled. It's just that you're probably going to get a different type of a benefit known as reduced earnings. So you can work and get a comp benefit. It's just that you have to tell the insurance company, number one, that you're working. Number two, you want to make sure that if you have a lawyer, you go to the lawyer first, let the lawyer do it. And three, you have to arrange it so that you're not getting paid twice for the same thing. All right? This is one that you should really consider carefully, and you might want to check with the board. If you have an attorney, go to your attorney first. Is a doctor's note stating I should stay home for periods of time equivalent to a degree of disability? Yes, but it's definitely not preferred, and you're definitely dealing with a doctor who doesn't understand comp and who's probably not authorized. Like, doctors will write a note saying, Sally worker should stay home until December 15th. They'll do that, and you give that to your employer, but that's not the best way to do comp. The best way to do comp is what the doctors who do comp understand. You have to file a report. You have to answer the 3 magic questions. Work status. Is patient working? Yes, no. Causality is what you're treating the cause of the work injury. Yes, no. Or is what you're treating a work incident? Yes, no. And then finally, what's the degree of disability? And you give a percentage, okay? So a note that says Sally should stay home for a few days, that's not a percentage of disability. So you should see authorized providers who know how to do this properly. Okay, that's what we have to say on that. So Sarah, we don't have any more questions in here, so I think I'm going to say thank you, everyone, and look forward to you joining us at our next. And I'm going to turn it back over to Sarah.
Thank you, Joe. And thank you to everyone for joining us today. I know we went a few minutes over, but just to get Joe's time for the Q&A is definitely worth it. So just a reminder, you can also sign up to receive workers' compensation news, including information on future webinars, straight to your inbox. To sign up, visit the board's website at wcb.ny.gov. Scroll down to the bottom of the homepage and select Get WCB Notifications. We also distribute information via our social media channels, so please follow the board on Facebook, X, Instagram, and YouTube. YouTube is where you'll see a lot of the videos and the recordings of webinars. So once again, we thank you all for joining us today and enjoy the rest of your day. Have a great day.